Center City, Philadelphia is defined by a dense, highly regulated grid of commercial development. Within this grid sits a specific mid-block parcel at 1213 to 1219 Walnut Street. The property currently consists of 4 individual lots, functioning as a single surface parking lot and a vacant building. In 2009, the owner, 1219 Walnut Associates, proposed a massive transformation, a 30-story mixed-use tower containing 152 hotel rooms and nearly 300 apartments. This proposal faced immediate opposition from Michael Singer, who owns the 2-story brick building next door that houses Fergie's Pub. Because the developer assembled the parcel over time, the new lot forms a tight C shape that wraps directly against the sides and the rear of the historic pub. Another neighbor, William Piper, joined the opposition, citing the strain such a high-density project would place on local parking and transit. The project effectively attempts to wedge a high-density skyscraper into a constrained footprint, forcing the surrounding properties and infrastructure to absorb the impact of the developer's scale. The lot is zoned C5 commercial, carrying strict limits on total building volume, required setbacks, and mandatory parking. The code permits a maximum floor area ratio of 1,200%. The developer requested 1,586%, an overage of 90,000 square feet. They also requested a variance to build flush against the pub's party wall, with 0 clearance. On the issue of parking, the code requires 266 off-street spaces. The developer requested a variance to provide absolutely none on site. Finally, the plan included a takeout restaurant, which is explicitly prohibited within the Center City commercial area. To justify these major deviations, the developer relied on the Hertzberg Doctrine, a state Supreme Court ruling that relaxed the legal standard for dimensional variances. The legal stakes center on whether a developer's desire for a high-density, profitable project constitutes an unnecessary hardship that can override the city's zoning code. The initial hearings took place before the Philadelphia Zoning Board of Adjustment. The developer argued their case under the standard established in the Hertzberg decision. Hertzberg ruled that dimensional variances, which govern things like height, width, and parking, require a lower level of proof for unnecessary hardship than variances that change the actual use of the land. For their evidence of hardship, the developer pointed to the physical shape of the lot. They argued that the mid-block location and the awkward C shape around Fergie's Pub severely restricted standard architectural designs and limited street access. Economically, they claimed that creating a critical mass of mixed-use density was the only way to make developing such a difficult site financially viable. During the hearing, the developer slightly reduced the apartment count from 299 to 293. This eliminated the need for a height variance and positioned them as a good-faith negotiator. The Zoning Board, supported by the City Planning Commission, accepted these arguments and granted all requested variances based on the site's unique physical characteristics. This gave the developer an initial victory, using the Hertzberg standard to frame a massive increase in density as a necessary site-specific solution. Singer and Piper appealed the decision to the Commonwealth Court, shifting their focus to the measurable consequences of these variances. They attacked the 0-foot setback variance, arguing it would have permanent physical effects on the adjacent pub. Allowing the tower to be built flush against the property line would permanently block the light and air to the pub, while stripping away its future development rights. The neighbors also challenged a variance that allowed the developer to shrink the required 60-foot loading dock down to just 45 feet. In practice, this means any standard delivery truck using the bay will protrude 15 feet into the public street, creating immediate traffic congestion. Piper attacked the total elimination of the 266 required off-street parking spaces. Center City is already plagued by parking saturation. Adding over 400 new units without a single parking space exacerbates an existing infrastructure crisis. These variances shift the operational costs of the new tower onto the surrounding streets and adjacent property owners. The objector's core legal argument sought to distinguish between a hardship of the person and a hardship of the property. Their primary tool was the Yeager Doctrine, established by the Commonwealth Court. Yeager holds that a variance requires a substantial burden that prevents all dimensionally compliant uses of the land, not just the one use the developer prefers. Applying this to the Walnut Street lot required a simple test. does the C shape actually prevent all by-right development? Factual evidence showed that a dimensionally compliant building of substantial size could be built on the site without any variances. This suggested that the hardship was rooted in the developer's financial ambitions rather than any physical limitation of the soil or geometry. Furthermore, the property was already operating as a surface parking lot. Because the land currently serves a permitted use with existing economic value, the claim of absolute property hardship is effectively neutralized. The objectors concluded that the zoning board had allowed a developer to manufacture a hardship simply to maximize their real estate yield. The Commonwealth Court agreed with the objectors, reversing both the trial court and the zoning board. The court ruled the zoning board committed an error of law and an abuse of discretion by finding a unique hardship where none existed. To strike down the dimensional variances, Judge McCullough applied the O'Neill doctrine. O'Neill states that when variances add massive amounts of floor space, in this case 90,000 square feet, and eliminate entire categories of requirements like parking, they are no longer technical deviations under Hertzberg. Deviations of this scale represent a de facto legislative rezoning of the property. Rezoning is an exclusive power of the City Council. By granting these variances, the zoning board had illegally usurped legislative authority. This left the final issue of the use variance for the prohibited takeout restaurant. The court applies a strict standard here. An applicant must prove the property has absolutely no value for any permitted use. Since the land was already functioning profitably as a permitted parking lot, the developer could not prove the necessary hardship for a use variance. This case sets a firm boundary for the Hertzberg doctrine in Pennsylvania law. The Commonwealth Court's reversal reinforces the principle that dimensional relief must resolve a burden imposed by the land itself, rather than serving as a tool to fulfill the owner's financial goals.